Good morning. Good morning. Can you please get seated?
Buenos días a todos. Por favor, vayan tomando asiento.
Good morning. Can you please get seated?
Sí, parece que sí. Bueno, poco a poco. Autoridades, señoras y señores.
Authorities, ladies and gentlemen, welcome to this introduction conference on the guide about the use of generative AI in courts. It's been created by the European Commission, by the CEPEJ. We now give the floor to Judge Francesco Depasquale, President of the CEPEJ.
Dear Minister Bolaños, dear Director Generals, dear Presidents, dear colleagues in law, we are all colleagues in law over here. Dear friends, thank you very much for this lovely occasion. It is a genuine pleasure for me to be here with you all today in this lovely setting, lovely city, as President of CEPEJ. And I would really like to begin by expressing my sincere and profound gratitude to the Spanish Ministry for this invitation and for hosting this important discussion over here. Spain has long been a key partner within the Council of Europe family, not to mention CEPEJ. And, if I may say so, it is one of the jurisdictions that has consistently demonstrated how innovation, digitalization and respect for fundamental rights can go hand in hand. For me personally, you are the leaders and a point of reference in the field of digitalization in the justice field. On a personal note, Madrid for me has a special place in my heart, as it was here more than 34 years ago, in 1992, when still a young, sprite rebel, having just started my studies in law, but that together with a couple of friends of mine who called ourselves very intelligently Los Tres Muchachos, I came to Spain and I embarked on a 4-week driving trip around Spain, which culminated in staying in Madrid, then European Cultural City of the Year. And for the first time I was exposed to the greatness of the Spanish culture and the ingenuity and inventiveness you have to push the boundaries of knowledge towards new levels. I may have had more than my fair share of cerveza and bocadillos back then. However, I can assure you that you really helped open my mind up. However, let's not get lost anymore in my personal anecdotes, because I am always well known that I will start and I will not stop. Let's come back to business. We are here gathered at a particular moment in time where artificial intelligence is no longer a fiction, as described way back in 1968 by Stanley Kubrick in the iconic film 2001: A Space Odyssey, when AI was depicted as this calm yet unsettling AI computer called HAL, whose famous phrase was, "I'm sorry, Dave, I'm afraid I can't do that," and which in the end turns against its master in an attempt to save itself. Nowadays, it is an undisputed fact that artificial intelligence, and especially generative AI, is no longer theoretical. It is present in court systems, in legal systems, and even in the expectation of the citizens. The question now is no longer whether we engage with it, but how. And this is precisely where CEPEJ steps in. I believe I can safely say that CEPEJ today stands as a key European standard setter in ensuring that the digital transformation of justice, including artificial intelligence, is guided by clear ethical principles. It is in the light of the advancements of AI that the publication of the CEPEJ guidelines on the use of generative artificial intelligence for courts is not just another document. It is in many ways a reflection of where European justice systems stand today and where they must go next. The guidelines, in fact, provide practical directions to ensure transparency in the use of the tools, accountability for decisions, reliability and security of outputs, and above all, the preservation of human judicial control. Allow me to say this very clear. At the heart of CEPEJ's work lies a simple but fundamental principle. The human being must always remain at the center of judicial proceedings. And this is so because justice must be served by technology and not be subject to it. This is not a slogan, it's a safeguard. Because while generative AI can assist by summarizing documents, supporting research, improving access, it must never replace judicial reasoning, discretion, or accountability. Spain, in this respect, is not merely participating in this conversation, it is helping to lead it. The leadership is visible in concrete terms. Through the CEPEJ's ICT Use and Development Index, Spain consistently ranks amongst the most advanced jurisdictions in Europe when it comes to digitalization and justice. This is also reflected in the rich contributions that Spain makes to the CEPEJ Resource Center on Cyber Justice and AI, where practical tools and innovations are shared across member states. The special mention in 2025 given to the hyper-automation of order for payment procedures and justice in the Crystal's case of justice is just another recognition of the results achieved by Spain in the field of digitalization. But perhaps more importantly, your rich contributions are reflected in your people. Allow me to acknowledge some individuals and contributions that make this cooperation so meaningful. We have colleagues and friends for me, such as Alejandro, Cristina, Maria, Jose, and Marta, who are all over here, who provide an invaluable contribution to the working groups of CEPEJ in cyber justice, quality, evaluation, and effectiveness of justice. Javier Ercila Garcia, who is also over there, provided us with invaluable work, as his expertise has been instrumental in shaping the very guidelines we are discussing today. Beyond CEPEJ, the broader contribution of Spain within the Council of Europe framework includes figures such as Mario Hernandez Ramos, the former chair of the Committee of Artificial Intelligence, who was instrumental in promoting the governance of AI in the Council of Europe. This level of engagement is not incidental. It reflects Spain's deep commitment to shaping the future of justice in Europe. This cooperation also extends beyond Strasbourg. I recall the EU High-Level Forum on Digital Transformation and Justice, which was held here in Madrid in 2022, to which CEPEJ was also invited, which demonstrated Spain's forward-looking vision in the field. Spain's strong engagement in the global fora is also reflected in initiatives such as the OECD Global Roundtable on Access to Justice and the World Bank's Digital Justice Working Group, co-chaired by Spain, in which also CEPEJ actively contributes. We have also had the opportunity to contribute to Spain's Data Forum of Justice, which provides an excellent example on how data can be used responsibly to improve the functioning of judicial systems, showing how data-driven approaches can enhance efficiency while remaining firmly anchored in the principles of rule of law. And just recently, Spanish experts contributed to discussions within the Council of Europe's new structure on emerging digital technologies, including the Steering Committee for Digital Technologies. All these things point to one thing: a strong, sustained partnership between Spain and the Council of Europe in shaping digital justice. And for this, I am always grateful. Now, turning back to the CEPEJ guidelines on generative AI, what is their core message? It is not to resist innovation, but to frame it responsibly. The guidelines build on the CEPEJ's earlier ethical charter on the use of AI in judicial systems, and they carry forward its 5 key principles: respect for fundamental human rights, non-discrimination, quality and security, transparency and fairness, and finally, human control. These principles are not abstract, and they are now embedded in a broader and institutional framework, namely the Council of Europe Framework Convention on AI, Human Rights, Democracy, and the Rule of Law, recently adopted by the Council of Europe. The challenge before us now is no longer to define principles, it is to implement them. This is also reflected in the CEPEJ Valletta Action Plan 2026-2029 on ensuring the efficiency and quality of justice in support of the rule of law, which is now also focusing, amongst other things, on supporting European judiciaries in complying with this convention in practical, measurable ways. In doing so, we are evolving. One of the key directions we are exploring is the creation of a judicial artificial intelligence observatory, a platform that will allow us to monitor, analyze, and support the use of AI in courts all across Europe and beyond. Not in theory, but in practice. Not in isolation, but through cooperation. Allow me to conclude with a few thoughts. We are often told that artificial intelligence will transform justice. Maybe it will. But the real transformation will not come from the technology itself. It will come from the choices we make about how to use it, whether we allow it to reinforce fairness or risk undermining it, whether we use it to improve access or to create inequalities, whether we keep the human judge at the center or slowly move away from that anchor. And CEPEJ's position here is clear. Innovation must go hand in hand with responsibility. Efficiency must go hand in hand with fairness. And technology must always remain a tool, never a decision maker. Digital justice and artificial intelligence must evolve together under a shared ethical framework, one that ensures that efficiency gains never come at the expense of fundamental rights. Minister, colleagues, Spain's leadership, expertise and commitment gives us the confidence to believe that we are moving in the right direction together. I am convinced that our collaboration and work will continue to thrive and develop in the years to come. Your energy and leadership gives us the strength to continue pursuing our goals to ensure that the protection of the rule of law is in the best interests of the citizens. Thank you once again for this lovely activity. Thank you once again for your leadership, and I'm really looking forward to hearing the discussions with your colleagues, and our friends. Thank you.
Seguidamente tiene la palabra el ministro de la
Next, we will give the floor to the Minister for the Presidency, Justice and Relations with the Courts, Félix Bolaños.
Buenos días a todos y a todas.
Good morning, everybody. Thanks very much, President and Vice President of the European Commission for the Efficiency of Justice. Thanks, Francesco. Thanks, Ivan. Thanks to both of you for acknowledging the effort and the leadership of Spain in this matter, not only in terms of digitalization, but specifically in terms of AI, artificial intelligence, as related to the legal procedures. Thanks very much. Welcome to Madrid. Welcome to our home. This is your ministry. Thanks also to the rest of the authorities present here. Thanks for being here in this home, in this headquarters of the Duquesa de Percent Palace, in this ministry. It is a pleasure for me to participate in this conference on the guidelines for the use of generative AI. This is at a very significant point in the development of digitalization and artificial intelligence in everything involved in the legal procedures. These guidelines that we are introducing, that we are discussing, debating in this very interesting conference, brings value to some of the examples that we are working on in our ministry, for example, the justice portfolio, Carpeta Justicia, or our policy for the use of artificial intelligence in the administration of justice. This guide, as the President of the Commission mentioned, has contributions from Spain given every day through a very relevant transforming work. I think it's cooperative as well, we believe. We believe in the cooperative work in the European Commission, in the multilateral institutions. We are contributing these two examples as best practices that can be made general in Europe. As the majority of the attendees know, we have an ambitious objective in the public service of justice. We are undertaking reforms that hadn't been implemented in decades. This is in this last mandate, a government mandate in the last 3 years. We've made reforms that have to do with the procedural efficiency of our system. We've incorporated measures and products and initiatives that are already yielding positive results in the management of our justice administration, like the adequate means for conflict resolution, conflict settling. These are yielding a very good percentage of results, 20%, I think is the last percentage, according to the latest data. We've also undertaken a structural reform in the courts. We've overcome the old one-person court model, and we've implemented the remote courts, which had long been requested. We are implementing that, and we're starting to have very positive data. The trend has gone down, which hadn't happened in the previous decade. But all this is accompanied by a degree of investment that is very substantial, very relevant in digitalization and artificial intelligence. We also approved, and this was a key rule regarding our workday, Royal Decree 6, 2023 on the digital law. The legal structure is very important, very relevant, but investment is even more relevant. Investment in resources, in means, in this term in office of the government, we've invested 850 million euro. 850 million euro in digitalization of justice. This multiplies the previous investment by many digits, but it is an amazing and very high figure when compared to any parameter. 850 million, and we are already seeing the results. We will continue to invest because this is not enough, but it does demonstrate an effort. It is a qualitative leap that is unprecedented in the history of our legal system, our justice system. So the connection between the procedural reforms to avoid unnecessary litigation. A judge in our country does not need to judge a case that can be resolved or settled by the parties. There is a very integrated culture in the legal profession, and also on the side of the judges. There is a very settled culture on settling disputes, and this culture needs to be made more general so that judges can resolve, can decide on cases where the parties cannot come to any agreement. So there's interconnection between the adequate means and the fact that we have distant courts, remote courts that can make all the resources be available in order to have decisions in a reasonable period of time. The fact that we can have a more rational investment, and not only that, the fact that in only 1 year we can increase the number of judges by 500. These figures are the biggest in the history of our country. Never before had so many new positions being created. This will be published in the Spanish official gazette very early. There will be a call for 700 new positions for judges and prosecutors. If we look at the past years, 10, 15 years back, there have been calls for maybe 70, 50, none at all. But this year's call that will soon be published in the Gazette, 700, is the same amount as the full figure of the last 10 years. And all this needs to go hand in hand with the investment and with the legislative reforms in digitalization. This is why this sum, 850 million euro, is so important. And this means that today the European Commission is acknowledging the leadership of Spain in digitalization, in artificial intelligence. But the CEPEJ already says that the expenditure by a person is above the average of the European Union, and after Estonia, it is a country that ranks best in the index measuring digitalization in the administration of justice. So it is second, above Germany, above Portugal, above Italy, only after Estonia, which is a very different country from ours. So these are the results. We don't want to sound triumphant. We need to walk on this line in order to consolidate this profound transformation of justice, of the public service given by justice, the justice system. So let me focus on the tangible results that these projects are yielding. They are transforming the way of working in our administration. The idea is for the legal experts of the justice administration, the judges. The idea is for them to devote their time to those tasks that give more legal added value, and not having to devote to repetitive tasks that can be dealt with by the technology. As happens it happens in every sector. The incorporation of technology is always a challenge. There's always people that believe that will be a problem. We should continue to do things as we had done them in the past. But I'm not the best minister for that. It's the opposite, in fact. I do believe that we need to transform, we need to digitalize, we need to reform our justice administration system. And this is why we are involved in projects that are leading us towards an improvement of the justice administration. And digitalization needs to be there to make procedures more agile, but also, why not, needs to be there to extend and guarantee the rights. The judiciary is a power of the state, of course, but it is also a public power that is there to guarantee rights. This is why we have projects that are capable to summarize legal decisions so that the people can understand these decisions in an accessible language. Necessary litis consortium is something we all understand, but the 90% of the population cannot understand that term. Having an artificial intelligence tool that can translate that phrase into Spanish, litis consortio pasivo necesario, or forgive me, I'm also a legal expert, but we have very complicated words for normal people. So having artificial intelligence tools that help ordinary people understand, this involves guaranteeing their rights, because it means that the citizens can understand what is happening in their own cases. But it also affects disabled persons. The fact that through AI, people who have sight disabilities or other types of disabilities, the fact that they can have tools to have access to the legal decisions that affect them means improving their rights, improving access to justice. And then there is the second part, the fact that we can make legal procedures more agile in Spain. Well, there was an increase in litigations and legal cases in Spain that caused summons to be delayed for many, many months. So when you receive a subpoena or summons to go to court, and you see the year 2029 on the letter, people think that there has been a collapse of the legal system, but this has in fact improved. So we can obtain very positive results thanks to robotics, to technology, to digitalization, to artificial intelligence. For example, we are now involved in robotics in a process which is about claiming defaults in invoices. This project involves a reduction of the cases by 60%. This robotics project, since 2023, has been implemented, has succeeded in the robotization of 250,000 cases, 275 cases. 1,000 cases. This involves 62,000 less hours of work that have needed to be devoted to tasks that have less added value. We have a president of the judiciary of Murcia. The region of Murcia has not had the powers devolved, the legal powers. So the average duration of these types of cases for defaults has gone down from more than 500 days to less than 300 days. So for people who were not paid an invoice, they have an answer in 1 year when they file the complaint. So we've reduced it by half versus what we had shortly ago, thanks to this robotization, this robotics project. So we will work towards making it even less time. Automation of the banking operations in deposit accounts. Those of us who practice law in the past, we remember very well what happened when there was a condemnatory legal decision against the company because they needed to compensate a worker for having laid him off. This used to be like a gincana, the fact that the worker would end up having the compensation or not. The delay might range from very small to very big, and maybe that person needed the money to make ends meet that month. So this is now automated, and in the territory of the Ministry of Justice, everything that has to do with deposits, payment to final beneficiaries of a legal decision, all that is automated in such a way that we have saved up to 500,000 hours of work, 500,000 hours of work of civil officials. We are thereby also guaranteeing rights because the worker that needs to be compensated or the wife that should be receiving the alimony amounts from her former husband because there's been a legal decision. All this is materializing in an extremely short period of time. So we are succeeding in both objectives, making the procedures more agile, and we are also guaranteeing the rights of the people who went to the administration of justice, the public justice service, to have their rights acknowledged and guaranteed.
Also, I want to refer today that we are going to talk about artificial intelligence to another project that we have already commented in CEPEJ, and I think is the way to go now in the administration of justice. And this is about the projects of automatized writing of drafts of resolutions. In this case, it's going to be about payment, orders, and abusive clauses. artificial intelligence can analyze all the information and create drafts so that judges and clerks can use these drafts to study them and analyze them and solve them properly. The work that we can save with this generation of drafts, is big, is huge in different repetitive orders when we have abusive clauses, which sometimes is not very complex in the legal world, but we think is going to help to have decisions in a much more agile way in the case of payment orders and claims for abusive clauses. And I'm going to conclude now, but I have to say that this is not just a debate whether to have technology that can help us or not. No, the technology is going to help us. This is going to be a benefit for sure. But the debate is how to implement technology better with the best practices available. Artificial intelligence is not here to substitute judges or lawyers. It's here to help them so that they can do the more complex tasks and the more valuable tasks. This is the way that we have to go through in the future in the justice area in the coming years, maybe very soon, because this is already here. And the meeting that we are having today, that you are having today, is just an example of how this is already a reality. And I'm going to repeat myself, I'm sorry, but this is going to be good for lawyers and judges. They are going to have less workload, especially judges, but also clerks. And this is going to be very good for the society as a whole, because it's going to guarantee rights. If someone has a problem, goes to the court, and this problem is solved quickly, is very good, because this person is going to have a quick solution, and this makes a public service as an exemplary one. And this is what we are doing in the Ministry of Presidency and Relations with the Courts. Thank you very much. So after this opening, we are going to have a very high value dialogue about the CEPEJ, its role in promoting the efficiency of justice, and the continuous support of Spain. We are going to have the participation of Ivan Jurgic, Vice President of CEPEJ and Secretary of State for Justice, Digital Transformation and Public Administration in Croatia, and our General Director of the Digital Transformation of the Administration of Justice, Mr. Aitor Cubo. Good morning, everyone. For me, it's a pleasure to participate in this event together, as Francesco said, my colleagues, my dear friends with whom I have been working for so many years to talk about the efficiency of justice, CEPEJ, in the scope of the use of generative AI. I know there is a lot of lack or fake news, lack of information on AI, and we think it is very necessary to have some guides, some guidelines to have this in a more accessible way. We think that from Spain, we can work with the CEPEJ in terms of justice efficiency, because the CEPEJ shows the standards, the metrics that help us analyze in ourselves and improve in the end. If we don't have information, it is very difficult to improve. And this comparative analysis or evaluation can help us improve and get better. And this is thanks to the CEPEJ and the support of the member states for specific questions and projects. Their support is one of the bases of the CEPEJ, I think. And we are really happy and glad to promote digitalization. Here we have representatives of the public sector, and it is very important for the justice to be more efficient. We want to be more quick. If AI can be applied to justice, we can apply it everywhere. In Spain, we are a referent in our support because we have a solid commitment with the European Commission and the Council of Europe, and of course with the CEPEJ to promote our law. And this is possible thanks to this active participation of different people and teams that create the tools that allow us to improve these tools that can provide diagnosis and are good for regulations and legislation. We also have good practices in the countries of Europe because we all have the same problems. So let's learn from other people, from other states, and copy them. So let's not waste time facing the same problems and find a common solution with the different states and the different situations towards a standard in Europe that in the case is completely aligned with what the CEPEJ promotes, because we have a common perspective of the future. We want a modern and efficient justice. As the minister has already mentioned and Francesco said, citizens are at the core and we have to take them in mind with a European tool. With this background from the CEPEJ, let's focus on reforms and modifications, right? Can we start with the proposals in terms of digital topics and digital issues by the CEPEJ? Can we talk about the different projects?
Thanks a lot, Aitor. First, let me start by thanking for the invitation. It's really great to be here. And, you know, I have already been invited twice for your Justice Data Forum. So I was in Granada, I was in Lyon, so I know what you guys are doing remarkably regarding digitalization of your judicial system. And I remember when your boss, Manuel, introduced you to me for the first time, he told me, I want you to meet someone. He's a genius who stands behind everything that we are doing regarding digitalization. So I'm really, no, it's really, I mean, yeah, but I'm glad to be able to have this dialogue with the genius. No, really, now not to just stay with my personal remarks. I think the numbers are really showing that you are doing great. Minister said something about that already, but you know, we have this chapter within our evaluation report, which is dedicated to ICT. And Spain is always somewhere in top on various indicators, various indexes. But maybe just to mention two, one is the average participation of implemented courts budget for ICT per inhabitant, where I think you are third, just behind Monaco, which is really small, so I think it's really hard to compare, and behind the Netherlands, but really high on this list. And also what Minister was mentioning, and I think that's even maybe the most important. So not just that you are investing a lot, what Minister was also saying in the digitalization, but the usage of ICT is really high. So there you are second after Estonia. So you really congratulations on that. Regarding the tools, yeah, I would like to say maybe also from my national perspective, for my capacity as a State Secretary in the Ministry of Justice, Public Administration and Digital Transformation, that CEPEJ tools are really useful. I'm not saying now just as a Vice President and member of CEPEJ, but there are really some tools that can help you a lot. And maybe just for you to get a picture, I come from a small country. Croatia has less than 4 million inhabitants. But when we started our work on decreasing our number of unresolved cases, and that was in, let's say, end of 2005, when we started our accession negotiations to enter European Union, we had 1.6 million unresolved cases, which was crazy. you know, for a country of 3.9 million inhabitants, 1.6 million unresolved cases. In 8 years, when we entered the EU, so in mid-2013, we had 800,000 unresolved cases, so we cut this number down in half. And these days, I was just looking at the data of the first quarter of 2026, so we are below 400,000. We had 382,000. So we cut this down in 20 years by 4 times. And we did a lot, and believe me, we used CEPEJ tools a lot. Even now, these days, or recently, when we are drafting some new tools, I'm always thinking, what should I give if I could have had these tools when we were in the middle of our accession negotiations, and we maybe wouldn't be making some mistakes because these tools are really easily to implement. For example, we have this, and you can all see it because it's publicly available, of course, on our website, our resource center on backlog reduction practices. So you can look there and you can see various practices from, you know, all around. So not all 46, but most of the Council of Europe member states who have done something in order to reduct their backlog of cases. It's there. So you can really find the inspiration there, and that's what we are doing. Fortunately, the judicial reform never stops, so we are still continuing to work on it a lot. Another interesting tool, I would say, regarding this organizational efficiency is definitely case weighting tool for courts, something that is very hot, very sexy topic, I would say, all around Europe right now. I think it can also help to help you, to show you how various, again, countries are weighing the complexity of their cases and what can it be used for. So for example, better allocation of human or financial resources, for better assignment of cases, for better court management, for help, support if you are restructuring, reshaping your judicial map. So definitely a tool you could also look into. I heard that here today we have some prosecutors. There is also one interesting tool which is called Time Management Checklist for Prosecution Services. So again, for you, there is a very interesting questionnaire, and you can see where you stand regarding the efficiency of your service, and of course how to enhance it. And I will finish with this one. Guidelines for creation of judicial maps. This is something also very interesting because, again, let me give you an example from my country. As I said, a very small country, maybe a little bit this shape like a boomerang, like a banana, and pretty specific, and a lot of islands, over 1,000 islands. But still, we have had until the beginning of 21st century too many courts. That's simply because this whole court network was established in mid-19th century when we were still part of Austro-Hungarian Empire, and when the goal was, to come to the court and come back within a day. And people were traveling on foot or maybe at best on horses or carriages. So, we had to do something about that because we had, in 2008, we had 108 first instance courts of general jurisdiction and 103 first instance specialized misdemeanor courts, so 211 courts. And here with this tool that CEPEJ is offering, you can get some ideas what to do, how to choose the size, how to choose the location of your future court if you are reshaping the network. And just over the years, in these 3 waves of this rationalization that we have conducted, from these 211, we have come down to 34, which we have now. I believe Spain has also some interesting examples here. I heard that you have some remarkable results with your new efficiencies law. So I will then give to Aitor maybe to say a few words about that also.
Sí, efectivamente, básicamente.
Yeah, basically, we had a little bit the same situation. We had a 19th century model of justice, which is quite surprising with all the changes that we have lived along the years in terms of economy and technology. With the Organic Law 1/20 2025, we have updated our system according to the CEPEJ recommendations and taken into account the model of Croatia with a much more efficient level and adapted to the needs of a dynamic society. The truth is that, and this is something that we are going to see, transformations have to be aligned with the society. Sometimes we need to have organizational changes to improve and to overcome old, fragmented and out of the reality models. We know that clerks sometimes do not play the same role in a criminal court than in a social court, where they have more different tasks. But we had just one clerk for both courts, and this was nonsense. So this instance courts give you a much modern management of resources. And those of us who are here, we have to be proud that we have done many improvements according to the correct deadlines that we established. And I know that we have to congratulate ourselves because this has become a reality, and it is reflected in the guides in the handbook of core management, which is related to this idea of professional and strategic planning of human resources that, of course, in a fragmented model, an old model that we had, you cannot do it. You cannot use anything properly. So the objective is to reduce, as you said before, backlog and delays, etc. These type of resources to reduce backlog of accumulated cases is another thing that we have to do and that we have done to implement measures and improve the public service of justice. And then this measurement system of the real or actual workload of courts is also very interesting. According to real-time data we are using, judges and magistrates participate in 40% of cases, abusive causes and things like that. So court number 3 was working a lot, and now we really know what is the workload of each specific case and each specific staff or people involved in the process. And this is fundamental to improve things. We had to update the organization that we had in the past. One fundamental question is that we have to, make this public. We have to approach citizens. I think that citizens have to know what is going on in the administration of justice. I think that the CEPEJ has worked on, raising the awareness of what we are doing. It's not just the public administration. We have to get to citizens in the society, in cities and countries. How can we do it?
Definitely, and CEPEJ has put a lot of emphasis on that. I think I can even maybe continue with the story that I finished my previous intervention when I was talking about this reduction of the number of courts. Because the main problem with this reduction was the public, and to be maybe even very frank, local politicians. So that was, the court was established very long time ago, but still each and every little town or almost a village which had a court back then, they thought that they are losing something really important if they will lose a court. The thing is that we, in fact, didn't deprive them of the access to justice. So that was something that was our crucial message that we wanted to send. So even in some of the biggest towns, we kept the building, we kept the court. It's just that there was no need for a court president anymore or for some auxiliary staff, but still the judging was happening there. In some smaller cities, we introduced so-called judicial or court days. So the judges would just come a day or two per week and perform their duty, so do their job. But the thing was how to promote that, how to make that clear. That's what I believe, Aitor, you were asking, and this is again when we have some interesting tools made by CEPEJ which can help you with that. We have one checklist for promoting access to justice, which does precisely that. Help you to increase the quality of the access to justice and to publicly promote it and to basically send a message. Also, another tool which is I think pretty helpful here are also guidelines for the evaluation of the quality of work of the judges. And they are putting emphasis not just on the efficiency, which we are mostly talking about as a CEPEJ who is dealing primarily with efficiency. You must never forget that the equality is important here. And of course, these are guidelines, so they are not trying to harmonize a very diverse I would say practice of all 46 Council of Europe member states regarding the evaluation of the work of judges, but trying to maybe set some criteria and set a methodology. But again, I know that in Spain you have some interesting examples here also with this, if I'm right, these justice offices you have in municipalities, so I think you are also doing some great things there.
Yeah, personally, justice offices in municipalities are very important. My father was a clerk in a very small village, and I know the rural specificities, and they sometimes lack services. And these offices of justice of municipality allow citizens to have justice. And as we mentioned before, sometimes they have to go to the headquarters of the court, but they can do most of their things there. And this is very important because of digitalization. Digitalization has to play a very important role. If you need your paper, you cannot get access to your electronic file if it's in another city. But thanks to digitalization, Spanish citizens have the right to go to their offices and receive all the justice services, those related to the judicial area, civil matters, and also administrative matters of the justice of Spain, like certificates, etc. And this is already a reality. I don't want to speak for myself, because for me, we have here the best example of how to apply everything, which is the president of the Extremadura court with Badajoz and Cáceres. And they were very successful because all the citizens that they have there have the same rights as those citizens in big cities. And in the coffee break, maybe we can ask them how to assist people in Extremadura removing movements and trips and travels, which is quite important. And I've seen the office in Formentera as well, where people had to use a ship, a ferry, to go to the corresponding judicial authority for a divorce, for example. The fact of being able to process everything in your office, in your city, is very important. And we are going to launch a project with the presidents of the Castilla y León court, with the participation of the Spanish lawyers, so that in all our communities and autonomous communities can have 100% of judicial services, because you have to imagine citizens in small villages, but they have the same rights of we who live in Madrid. So we recommended 2 guidelines that you mentioned, the checklist to promote access of justice. We have people from the autonomous communities, and this checklist allows you to say, okay, I missed something, so let's look for it. And also for judges and other experts, it's very important for them to use these guidelines, because access to justice is fundamental for citizens to improve a public service and to improve their access to a public service. Organization is necessary, I think, but also procedural science. And what are your recommendations in terms of procedural matters or science?
Well, this is something that CEPEJ has been dealing also a lot recently, specifically with the alternative dispute resolution. So this is ADR has been in focus of CEPEJ for a few last years. And here again we have some, I would say, interesting tools. One is a guide on participation of children in family matters, which we believe is very in family, in fact, mediation, which is very important in order to for the kids, for the young people to simply have the ability for their voice to be heard. For example, when there is a divorce, when there is a separation, so that they can express their wishes and their views. Another, I would say, interesting tool here is the one which is dealing with, it's called Guidelines on Online ADR, on Online Alternative Dispute Resolution. And it is, I would say, very broad. It is covering all different forms of ADR. So conciliation, mediation, of course, and negotiation. Unfortunately, from the national perspective, I cannot say that we are good here. I often think that, in Croatia, our citizens are very litigious. Everybody wants to go before the court, and no matter how much we try to promote ADR, it's not working. We are right now in the middle of adopting a new mediation law. We have just passed the first reading, and now we are sending the second reading to the Parliament, and we are establishing a new national center for mediation. So we hope that there will be some steps forward. But here, I would in fact like to hear your story more, because we really are here struggling, and I was really wondering, is situation in Spain any better? Is ADR becoming more popular, and what are your experiences with that?
The experience of the application is or has been commented by the ministry. Litigations have been reduced in the last 10 years with support to use different means or to different resources. Sometimes we can come to an agreement before going to court. And the promotion of these alternative conflict resolution tools makes the process easier and more efficient. And I'm going to say something about my team. I'm going to talk about the cases that I remember of litigations. One is from a friend of mine. He wanted to go to the dentist, and she was claimed the payment, but she had already paid, and she received a letter, and she could solve the situation quickly. And then I have another case of a neighbor, and together with a letter and the alternative dispute resolutions, they could solve the situation. And this is what is happening in Spain. We are reducing litigations in courts, and I think that now we need to improve timing and backlog to get to previous agreements. You mentioned minors and children. I think that it is very important to come to an agreement when we have children involved. In sometimes the fathers, the mother, and the father are angry, and we can put minors at the core as a fundamental part of the process, as you mentioned in your guides. So we need to promote these alternative methods with the participation of different organizations who are sometimes NGOs and different organizations that can be a way to reduce litigations and our trend that we have in the different judicial systems.
So, organizational, procedural improvements, but what can we do also with regard to the digital improvements in the field of justice?
I think this is the most important thing. To be honest, at least for CEPEJ, in the last few years, the focus has been on digitalization. So we have a working group on cyber justice. Alejandro here is our member, very active member there. And we are working a lot. I mean, you are working a lot there, and a lot of interesting tools have been made there. I mean, obviously, the topic of today's event is the guidelines on the use of generative AI for courts. I will not speak much about them because I think there will be more about that later on. I can just tell you that we in Croatia have also taken CEPEJ guidelines as an inspiration. We have just drafted our guidelines, national guidelines. Last week, I have just handed them over to my minister a few days ago. He said that he likes it. If he is not lying, I hope that we will soon have them adopted. We are basically sticking with the let's say, the most important messages that CEPEJ guidelines are sending, and this is that there should be an effective access to human judge. It should be guaranteed that the outputs made by AI should not be binding, and that everything that has been done by generative AI should be very transparent. Another guidelines which I also found pretty inspiring on our national level are the guidelines for online publication of judicial decisions. And this is something that was also made a few years ago, and we also used it when we were upgrading our application for publication of jurisprudence. To show you maybe, I think, the impact of AI, because now we have the system which is, of course, AI-based. We used to have another application which was running for 15 years, from 2010 till 2024. And we were publishing all the judicial decisions of the Supreme Court and most important decisions of higher courts. And over this span of 15 years, we have published around 330,000 judicial decisions. On the 1st of January last year, we started with this new application, which is AI-based. We have, of course, transferred all these 330,000 in the new application. And we started this anonymization and publication of all the judicial decisions. And within these 15 months, we are at a number of slightly above 1 million. So 330 in 15 years and almost 600 or 700,000 more with AI in just 15 months. So I think this is really showing how powerful AI is. And I will finally conclude with another. It's a little bit older guidelines on e-filing from 2021, but again very important. It can be also very well used. In Croatia, we have used these guidelines also when we were changing and taking the e-filing as, like, say, the normal way of operation, of communication, of exchange of documents between courts and the clients. So we did it first in civil and commercial, then in administrative, then in criminal proceedings, and now we are right now also introducing e-filing in misdemeanor proceedings.
¿Qué voy a decir de ese tema? Que es el que más conozco, el que más soy responsable, el que...
What can I say about this topic? It is the one that fascinates me. I'm passionate at it. The reality, and I was mentioning it to the minister, is that we have facts. We have colleagues here that can confirm that 3 years ago the regions did not have the electronic procedures, electronic filing of procedures, and we are now using all that in the AI part. And when it comes to eliminating the repetitive tasks, well, we have improvements thanks to automation, artificial intelligence. Again, over coffee, well, we have the Murcia president of the judiciary. Of the Supreme Court of Murcia, sorry, we can deepen more into what they have achieved with real results. For payment procedures, the period could be infinite, but now we are shortening those periods very much. And we are working hand in hand with the judiciary, collaboration, non-intrusion in the other jurisdictions. All that collaboration is extremely good. I'm not going to make any reference to the publication of decisions, because this is also the jurisdiction of the judiciary, the Council of the Judiciary. So I'd like them to be the ones who explain that. But indeed, what is being done in Spain is very interesting, thanks to the impulse, to the push of the General Council of the Judiciary, thanks to the push of the administration. The minister already mentioned the results. The Murcia results in terms of payment cases are amazing. The consignment accounts, we have representatives for different professional collectives. They tell us that the problems are that, well, there's so many new things that we have problems accessing the information. From Carpeta Justicia, Justice Portfolio, professionals and citizens have the possibility to do payments through credit card, and it is automatically managed by the procedural system. This is amazing, and there are AI services, generative AI services that are at the service of the citizens. It's very important to increase the efficiency of the court from within, but we also need to leverage the new technologies to improve the access to justice. Our idea is to try to lead with something that we have from the private sector. Leading the implementation of these systems in justice, because why not use them for civil cases or for works licenses in a city council? This improves the efficiency of the government, of the state, because the figures are showing the results in terms of consignment accounts. 13 billion euro have been handled. We now have generative AI. Today we are introducing the CEPEJ guidelines. I encourage all the attendees through the internet to take care of these aspects, because adopt all this, because we can achieve an ethical view, 100% respect of the rights of humans, being a continent or being countries, or being a country in our case, that leads the implementation of these technologies. We did not generate the technologies, but we are excellent at implementing them in order to achieve a justice system that is much faster, much more efficient, much more adapted to the current times, and improving this public service for citizens. So I encourage all of you to look at the guidelines and follow the best practices. Thanks very much.
Thank you. Thank you, Aitor. Thank you.
Concluido este diálogo.
After this dialogue, we now invite you to a coffee. We have a break, and we will resume at 11:35. Thank you.
Well, good still morning, everyone. It's a great pleasure being here. Thank you very much for the opportunity to talk about digitalization and AI in Europe. And it's a great honor being here with you. So distinguished guests, dear friends, I was asked to talk with you about and see how AI or generative AI is used in Europe. So I will not talk a lot about Spain. I will give more comparative perspective. And I think it's also worth to explore the question with it. So does it make justice better in the end? So more efficient and fairer, because I think that is the main idea why we're doing all this. To start with, it's not such an easy task to see in a comparative way how AI or generative AI is used in Europe. So we don't have many comparative sources. I think one important source was already mentioned this morning. It's the CEPEJ ICT Use and Deployment Index, which has some limited questions about the use of ICT and also AI in this regard. So we can see if there are tools of anonymization also, or in remote hearings, AI tools for witness protection, subtitling, or where there are also tools for recording of hearings that have AI elements in them. Another source is the EU scoreboard from the European Commission, where also the CEPEJ is contributing to. So main part of the judicial statistics come from us, from the CEPEJ. And there are only two questions, basically. One is related to chatbots, where that is used for citizens to give information about the justice system. And you can see this is identified for Germany, Spain, Latvia, Greece, Croatia, and Portugal. And more direct is a question on the use of AI in core judicial activities. Now, of course, it remains a question, what is a core judicial activity? So this is why the findings there are only indicated for Austria, Germany, and France. So this is why the CEPEJ made the effort to create a resource center on cyber justice and AI, because in the discussion about AI, we have a lot of talk and a lot of fiction, basically. And our purpose is to identify what is really used, what are really the tools that are used by the courts, or also in the wider sense of the judicial system. The question for us always is there in this regard also, is it really AI? Is it generative AI? Sometimes it's difficult to distinguish these particular issues there. And what we do also on top of this, to identify this, we had an ad hoc survey with the European Cyber Justice Network that we maintain to really dive more into the issue of generative AI. So this is the AI tools that generate things, large language models that we interact with an interface of a chatbot that are known like MS Copilot or ChatGPT or other ones, and how this is used in the area of justice. So the first findings to look at is we see a map, and the darker the country is, the more tools there are. And I think Spain is clearly identified, as was mentioned this morning. So this is also really empirical evidence quite prominent in this area. And I think it's important to see also, to discuss what these tools are used for. So where are they useful, where they're not useful, and what we see in Europe in this regard. So we have broad categories, so it's mainly for document search, review, and large-scale discovery of issues. You see the spheres that are displayed there on a display. The bigger the sphere is, the more tools are existing in this area. So I just mentioned a few, or go through it. We have online dispute resolution. We don't have so many. This is really the idea to have online portals where a conflict is mediated electronically, and also with the help of IT tools. And many widely discussed issue is the prediction of litigation outcomes. I think that's the most interesting. So the so-called robo-judge, does it exist or not? We do not see much evidence for this. So as you can see, the small red sphere, really prediction of litigation outcomes, is an area that is not much developed. A big area, and I think that is very interesting for generative AI, is decision support. So as we talked about also this morning, it's not about taking a decision fully autonomously, it is supporting the judge in the decision making. And there we have quite some tools. So tools are also recidivism assessment tools, but also editing tools, text generation tools, and so forth. We come to some very established areas, anonymization and pseudonymization, of judicial decisions, that we see that this is done now mainly by AI in Europe. So there's very few cases where this is done manually, again, like we heard also from Croatia. And a big area, the yellow sphere, is really the workflow automation. So if you have an e-filing system, applications comes in, they're identified, different information is taken from it, and the workflow is optimized by routing these applications to the appropriate location. And again, recording, transcription, and translation are also services that we see increasingly rolled out and where AI plays a major role. Interpretation, not so much yet, but the colleagues are working on it. And information assistance services, chatbots for potential litigants, potential court users to get judicial information. This we see also being rolled out in this area. Now, but what about, just to give you an overview, what about generative AI? So there also we have to look a little bit more in detail. So as we can see, most courts are having already AI tools or are working on it. So when we talk about 46 member states of the Council of Europe, and when we talk about generative AI, so it's not that advanced yet. So the colleagues are still trying a way of finding a way of making this technology work for them in a reasonable way and to exploit the potential in this. I think it's very interesting in this regard to see what kinds of tools they are using, because we are advocating for the development of in-house tools that are specialized, that rely on good databases and so forth. But we see that actually currently many courts are using off-the-shelf tools, MS Copilot, so they basically have a special contractual agreement, the standard agreement of 365 Microsoft, saying that your information will be treated confidentially and it will not be used for model training, which of course leaves a big question mark to us in this regard. But this is what we see. This is a bit small. I will summarize a little bit what we see, what generative AI is used for. And this echoes also very much what we were talking about this morning. But for us as the CEPEJ, it's really important to have some empirical evidence to be clear what we're talking about, to identify then also the issue. So big area, so that most courts mention, is the summarization of documents, of large case files and so on. As mentioned, transcription generation of hearing minutes, speech-to-text software is very much developed already. We have also the use of identification and extraction of specific information in documents. Translation is a very big field where it's used. We have some uses where it's really used to make it more transparent, more accessible, translation into easy or plain language for people. And of course, it is used for linguistic correction of documents. I think that is also a use that many non-judicial staff are using AI for and finding some use of it. When it comes to legal research, it's also used there. That has to be seen a bit more carefully because it depends on how you apply it and how you use it, but it is definitely used. And it's used for drafting other texts but judgments in this regard. It's used for analyzing document coherence and workflow automation, other ones. From the other parts, I would just like to mention few mentions where there were not many. It is used partly in the adjudication of mass claims. I will come later to this also, so very uniform cases in well-established situations. But also in verification of admissibility in some cases when applications are handed in an unstructured form. And what we also see, and I think that is important to underline, that we didn't have any mention of the use of generative AI for the quantitative estimate of legal outcomes. This is basically the legal prediction we are talking about. So we conclude already that there is activity, but so far we see a relatively reasonable and responsible use also of generative AI in this regard, which was also confirmed by our discussion we had this morning. I would just like to illustrate this a little bit, pick some examples that I think are interesting or representing the use of generative AI in Europe in this regard. Document search, review, and large-scale discovery, I think that is clear too. That is also used a lot by lawyers in this regard. I have to say also we are focusing really on the public side, on the courts. We are not covering the whole area of legal tech, which is very wide and which is promising all kinds of functionalities and use, but we think the courts really have a different role. You have to ensure the fairness of the trial, so it has to be a different standard and also application of this. In online dispute resolution, as said, we see very few really fully automated tools on this. We see some tools that have elements of AI. It is more guiding, a step guide through a procedure and then generating also an outcome. And in Europe, we don't see much of this. Coming again to the prediction of litigation outcomes, we see recently that colleagues in Bulgaria are planning exactly to do this. So we will have discussions with them too, because we're very curious what they are doing. We know of others who are also using it for prediction, but it is more predicting of potential costs of a case, or the duration, like we heard, is done in Croatia for specific reasons, where we say this is more administrative. Talking about mass claims, I think that's an interesting area, and in the talks before, I heard that this is also looked at here in Spain. I would like to mention an example that was happening in Germany. It's a case or a system called Olga, Oberlandesgerichtsassistent. It's an AI. The situation was like this in Germany. You heard a couple of years ago, we had a big scandal about the car manufacturers, and they were basically falsifying the emission values of cars, Volkswagen, Porsche, all the others, and so on. And basically, the cars lost resale value. And now, after that was established at the first instance, it went to the appeal stage, and the appeal courts were faced with thousands of claims that were very uniform and the same. And the difference was only when the car was purchased, what are the kilometers, and so on. And the colleagues, as there were 5 judges, they built an AI in the e-filing application to identify the specific information and to automatically generate judgment based on a well-established case. But the difference is that the judge had to sign it off, and the judge was able to identify and to trace where this information was coming from in the applications. And we think that is definitely a way forward. Anonymization and pseudonymization, as said, that is relatively way established. Workflow automation, the same. We have cases like Austria where a file comes in, if it's on paper or electronically, it doesn't matter. It gets automatically routed, the whole process. And recording, transcription, translation too, and information assistance services. We see increasingly chatbots, ChatGPT interface, where in Portugal, for example, you as a citizen can communicate very naturally with a machine, and you can ask in divorce cases or in case of founding of enterprises what steps to take. It's important. It's not legal advice, but it is an application of generative AI in a responsible way that we identify there. Now, what can we conclude out of this to come a bit there? So we see definitely in Europe a very fragmented use of AI. So it's really not uniform, and even if we look at the countries, it is very diverse. It really depends partly on court level. So we have not many countries where in Spain where much work is really done also by the Ministry of Justice in this regard. I mentioned the technology hype cycle, that we mean that really we are on totally different positions when it comes to the application of generative AI. So we have some colleagues who still have the wildest ideas what we could and should do with it. And we have some others who say it all doesn't work because they tried. But we have some others who are now really on a path to have a productive way of having established, okay, this is what we can do, this is what we can't do, and this is where we want to go. But this is very diverse. What we also see, and I see this also in talks we are having when we talk about automation or different activities, digitalization of the judiciary, we really see that AI is now driving also digitalization and automation. But it's clear not everything that is automated is AI, so it has different risks, but it's an important discussion that we have to take, because I think the potential is not only in AI, it is really also in the whole digital path in this. And we see also the number of specialized tools increasing in this regard that the courts are applying, but we see at the same time also a very fast increasing use of standard tools, ChatGPT, a tool that is not designed for the judicial context, that is following different data protection contexts. But we see this increasingly being rolled out, and this leads to a use of shadow AI. Shadow AI, what I mean by it, so use of AI, also by judicial clerks or judges even, which is not disclosed and also not really verified the outcomes. And why are we talking about this? Because generative AI has two big issues. The one is the hallucinations, so that the outcomes somehow need to be verified because they are not always exact. And the second is the data protection issue. So the judicial context is very peculiar in the application. So shadow use of AI is different if you're trying to, I don't know, look for a house to buy or shoes or whatever, or if you work in the judicial context with it. And we see also, as I said, some tools are really standard by now. Anonymization, we think there's no turning back anymore. If you have an e-file, if you have an electronic workflow, so at the end comes the anonymization and publication through an AI system. I think what is very important to talk about at this moment, and when we talk enthusiastically about our potential AI systems that we're having, is we have a change in the regulatory landscape. And we have the Council of Europe Framework Convention on AI, but we also have the EU AI Act here in Spain that is applicable also there. And first of all, we see increasingly national regulation that is coming out. So we know also about the policy in Spain on the use of AI in the judicial sector. So we appreciate this very much. But we have also the EU AI Act that is entering into force in phases. And when we look at the area of justice only in this regard, so we have a prohibition of crime prediction systems in this regard based on the EU AI Act. I think very important for the area of justice because these are exactly these applications that are very, very emotionally discussed, and for a good reason, I think. And also what is happening, large language models are required now to document on their transparency on the data used for training compliance and with copyright law, which was not the case before. And in August, something will happen in August, obligations for high-risk AI systems and tools in the judiciary that at least intended to be used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts, fall under this, and which requires fundamental rights impact assessment of these tools. So we have a situation where some of us who have tools have to do this retrospectively and apply it. But we think that is a very good move to reduce the risk of the wrong use of these tools. Coming back to the question, does it make justice better? We think yes, so that is our first assumption. But again, for us as the CEPEJ, it's important to look at this a little bit more in detail. And we have evidence for efficiency, but they are very case dependent. So we cannot really generalize this for the use of AI or generative AI on all cases. As said, the Olga case, you can calculate how many thousands cases you had and 5 people who resolved them in what time. We have the same thing when we talk about the payment order procedure or other automated processes that you might have for your tools, where you have an assessment very well with a view to efficiency. And we have also cases where people look more on qualitative elements, or if this is posing additional barriers to the litigants, where we have cases also in the UK where this was reoriented then after an evaluation like this. I think what we should also keep in mind, as much as this can all do, there are many unforeseen secondary costs that are not anticipated in the beginning on the application of AI, and in particular generative AI. Because when we talk about supervision as a requirement, is sometimes negating, in specific cases, the efficiency gains you might achieve in this regard. Also, there are other investments that some people are not fully clear about if you take it seriously, which is into data protection, cybersecurity. We have some countries which, under the heading of data sovereignty, are increasingly for the judiciary building their own data centers, cloud services, to have also the data under judicial control and in the European data protection context. So this is, of course, related with huge costs, but can be also seen as an opportunity in this regard. And there's also currently no way of empirically measuring if it makes justice better, but we assume there is. Maybe the CEPEJ one day will come up with a way of measuring this, but to underline, if applied by an experienced user. We have the cases where a judge tells us, I use MS Copilot to do my judgments. Everything fine, the person knows what he or she is doing. We have others where you have the idea to give an unexperienced person this tool to do the same. You will unfortunately reach a different outcome. I think that was a little wild ride through the landscape of Europe that we are having. But it should give you an indication where you are, and I can confirm also on a empirical level what was mentioned this morning, that Spain is really far advanced in this area, and we are very interested to learn also from you how specific tools are working, and would like to thank you also for this opportunity today. Thank you.
Continuamos la sesión con la
Going to continue with Javier Hernández's presentation, the Subdirector of Digital Services of Justice. Good morning, everyone. Especially welcome, dear CEPEJ colleagues, Francesco, Daniel, and Ivan. It's a pleasure to have you here, but I want to overview a little bit the use of AI in Spain. We started 5 years ago, and I want to start with the origin of this digital transformation that we are experiencing in Spain. The first ministry was the Ministry of the Presidency in creating a digital transformation process. So there was a political will that was very important to provide the service that the ministry provides. And this has to do with the IT systems of the autonomous communities and the country and the justice of the country, and then the services that we provide to the minister itself, the ministry. So we give or provide services to more than 25,000 internal users and 300,000 external users. We have more than 200 digital services, more than 20 AI initiatives, and more than 25 RPA initiatives. When we started the project of IA, the main problem we had was that we had a digital justice system which was not oriented to data. We could not exploit it. We didn't know the reality of the operation of the administration of justice. We didn't know when, for example, there is a case of violence or gender violence. We didn't know the place, for example, where it took place. And we tried to had a project, which is the creation of a project of justice oriented to data. And we approved what we call data manifesto, where justice data are public data. Of course, personal data are not part of this area. But interoperability, legal medicine, disability, violence, traffic, drug consumption, etc. These information started to be published by the regions and by the ministry with the intention to create a confidence space to share data to support the society to identify problems in a better way. And this was reflected in cases of suicide, for example. We cooperated with the health department, and we are moving forward in this regard. So justice-related data can be reinforced because artificial intelligence, and they can be applied for the application of public policies. So justice is gaining value. We are not restricted to data issued by the Council in terms of statistics. We are trying to compile data, high-value data, to improve the lives of the citizens and institutions. When AI started, we drafted the first policy of AI aligned with the work of the CEPEJ, both with artificial intelligence guys and statistics, because they really understand data analysis to help Europe work better in terms of justice, identifying and comparing ourselves with other countries. When we talked about AI, then artificial intelligence regulation took place, where for the first time we mentioned artificial intelligence for specific processes, but not for judicial decisions, just to improve the efficiency of justice. At that time, with the first artificial intelligence system, we understood how or why the society and the Justice Department was worried, because we were pioneers in the general administration of the states in publishing fact resources, where monthly we published all data that we used, biases, AI services that we used, the language models that we used, the applications of them, the members of the team involved, and many other types of information or pieces of information. This publication takes place every month. You can see it on the website of the ministry and provides confidence to the system as a whole. One of the problems we had was a lack of trust in the systems. So as years went by, we are seeing that this has more value now, thanks to the AI Act, where we can analyze the systems of the ministry and where everybody can have the necessary information. As you know, we provided all the information to the Council of Europe. When we talk about data, in 2022, where we developed the manifesto, we also developed a portal which is called Justice in Data, to have access data about sexual violence, traffic, as I said before. This portal is public and has high-value information for those of you who are interested in the areas covered by the website. Justice is everything, as you know. Justice interacts with everybody. So the first analysis promoted by the General Director pursued that each of the interactions with that we have a communication related to data, not just an exchange of information, PDFs, etc., but also data and specific information, because we can apply automation or we can apply artificial intelligence. In the current status of artificial intelligence, we can apply it to extract data and include them in the system. So the increase of efficiency can be exponential. This analysis is continuous and is going to improve in the coming years. We have the cooperation with the police forces because we want to integrate cases with data, not just information of claimants or the crime itself investigated by the police. We want to incorporate all types of information about where things took place, objects that were confiscated, all type of information, so that the information can be shared by all institutions that are involved in a procedure, and it's related to data so they can automatize processes. So when we had the information, we started to exploit it. We extracted valuable information to know how many hours of work we save, how we can improve the timing, what is the impact of saving sustainability issues. And this information allows us to give information to the politicians to implement public policies and know what bottlenecks or where bottlenecks are. As the minister said before, we have improved the situation thanks to these robotization processes, which is like a double automation. We introduced more data to the automatic process to have more automatic routines. Minutes, for example, or actions taking place in the judicial procedure are related to data, and we have the Murcia precedents here. And robots, chatbots, know exactly what to do in terms of the procedure. This work is automatizing a high percentage of payment orders, for example, but we are also working in the fact that we have like an architecture of generative AI that is going to allow us to create documents in an automatic way. This is not about making decisions. This is about drafts or different types of documents. And we have different initiatives that I think are going to be very interesting. This is about the story or the history of artificial intelligence in Spain, which will then be commented by Alejandro. But I'd like to talk about the last things that we are doing now.
Yes.
We are creating drafts of decrees for decisions about payment cases. We are creating decisions drafts for simple cases. And we've just implemented the automatic generation of the drafts of the texts for assessment in alcohol-related crimes, to send them to the prosecutor's office. We're also automating the registry for a pool of more of 10,000 pending cases at the Supreme Court. We're just grouping them in procedural pools. We have a very powerful generative AI system that extracts information from the resources, asking the accused person so that the Supreme Court can have a list of 10,000 cases, grouping them, knowing how to handle them, what priority to assign, so that we can eliminate all this backlog. We're using generative AI to analyze decisions. In this case, we're using it for gender violence cases. We are also creating the basis of a future of artificial intelligence in justice during the next 2 years. I cannot talk about timing because what will happen in 2 years, we don't know. But it is a multi-agent architecture. Artificial intelligence is talking to each other, everyone using a different type of language, doing different tasks. One of them can extract information wonderfully. The other one validates it against the jurisprudence. Another one makes sure that the shape of the data comply with the format allowed for by the system, dates, for example. And this architecture of agents becomes shaped for the appropriate output. This is especially relevant for the system that I mentioned, for the generation of drafts, for the orders that conclude the payment cases. Everybody extracts the information they need and they do the checkings. If there is this invoice or not, if the entity is financial, if it is a revolving card. It allows us to evaluate, to assess by means of different, very specialized agents. We're not talking about generalistic generative artificial intelligence, which can also be very good, but we cannot permanently use ChatGPT, Cloud, or Pilot for every document. That would be impossible to handle. It would be a financial failure because it costs a lot of money. There is a system that we are used to. So in this saving of costs, looking for efficiency, we are creating little agents that will do something very small but very, very well. And this RAG architecture for extracting information, well, we have now some kind of tender between 5 companies to do a RAG proof of concept that is deliberative. This means that we will provide a pool of data so that it can do inferences, reasonings, about what they say. It is a proof of concept. We need to see how it comes out. So we're starting to try to do second-order derivatives. It's not just having a conclusion, but also relating to other elements. And this allows us to locate the part of the document in which the system has an inference. These are the fools of innovation. So we hope in a few months, when the proof of concept finalizes, we can give you more information. In addition to these systems, we should not forget the infrastructure itself, the suitcase of tools for judges, for legal experts when working with artificial intelligence. There have been some courses about the use of Copilot, which is our generative AI corporate tool, and we are aware that it is being used a lot to generate summaries, many other tasks. It can also be used in a safe way because it guarantees the personal data protection for the documents that are introduced in the system. And we believe that in truth, it does have a long pool of applications. We are changing the computer system. We're moving from Minerva to Andrea, which is very modern. So one of the proposals of our training department, they sent an email saying upload the Copilot tools and start asking questions. How do you initiate a case? I'm just an engineer, I'm sorry, but it allows you to express yourself in your natural language. It is useful for me to have knowledge about an immense field. So this event is proof of that. This can only be done in a reliable and efficient way if we do it with all the actors playing a role. So what good would the electricity invention have been without the intervention of all the parties? With artificial intelligence, with the digital transformation of justice, it is a little bit the same. Justice is a very peculiar system in which there are lots of elements on the chain from the person that initiates the case, the complaint, and the judge. If all the elements in between are not coordinated, the system fails. If some part of the chain bans the use of artificial intelligence, this was the situation 5 years ago, what happens? Well, our legal firms might be using artificial intelligence, generating automatically 100,000 complaints. If we cannot process, if we cannot have equality in terms of the tools we use in order to support what the society has a right to do, then there will be inequalities, impossible to manage. So from professionals, decision makers, lawyers, judges, and citizens. They all need to be users. They need to be aligned with the responsible use of AI in a useful way, so that they can associate themselves to the administration of justice. Events like this, or the forum of digitalization forum of the administration of justice, with the presence of the industry, these events allow us to identify where we might have problems, where we might have lots of benefits. Thanks very much for your attention.
Pues una vez explorado el
Once we have explored the use of generative artificial intelligence in our country and in our continent, this is the time to tell you more in detail about the document that inspires this event. And for this purpose, we have invited the expert that conceived the first draft of this, Javier Ercilla, judge of the Canary Islands courts for company matters. Good morning. I've been asked to explain the guide a little bit. This is, and they told me I only have 15 minutes. Andy Warhol said once that everybody deserves 15 minutes of fame. So this is my time. Thanks to the CEPEJ for having trusted me to create the first lines of the draft that later became the document. And I'd like to start by telling 3 different stories. Firstly, the last sanction from the Superior Court of the Canary Islands, sanction on a lawyer for having filed a claim with 48 false or faked, untrue jurisprudence quotes. All of them decisions of the Supreme Court with a date. The good thing about artificial intelligence is that if you know the pattern, the AI knows more or less when the decision was issued. But then the story of the complaint filed by a lawyer with the General Counsel of the Judiciary in Ceuta because an investigation judge had used artificial intelligence in a legal case. But there's a dramatic turning of the events because the judge had not used AI. He had just copied the legal documents of the prosecutor's office. So it was the prosecutor's office that had used artificial intelligence. Thirdly, third story, the recent disciplinary file initiated against a judge of the provincial court for having used artificial intelligence in a decision, including the questions that AI had asked him. 3 different cases, but they show the same situation. Artificial intelligence is part of the justice systems, and the guidelines respond to something. And they respond to these 3 situations: how to apply generative artificial intelligence in the field of justice, both professionals, prosecutors, and judges. The guidelines are not an enthusiastic or technologically enthusiastic document. They're not a naive text regarding the possibility of applying artificial intelligence in any field. And it is not a document that shows fear of applying artificial intelligence because of all the risks. On the contrary, the basic idea is like the magician cannot go back to the lamp. So without losing the guarantees as citizens, it is something we have conquered or given ourselves. Through the different drafts, as civil lawyers, I've used a Latin expression. A Latin expression that is not present in the final document because all the member states have different legal traditions, but the phrase defines with clarity what the philosophy of the guidelines is. The expression is non reformatio impeius. From the procedural perspective, when one of the litigants appeals, then the Supreme Court cannot place the complainant in a worse legal situation. So this is the element that translated into the guidelines shows that we want to reform the legal system, the judicial system, but never going worse. And for this purpose, I will give you 4 points that define the spiritual way of interpreting the text. The technological subsidiarity principle. When I spoke about to Daniel and other members of the CEPEJ about the drafting of these documents, the drafts of the guidelines, I looked into the different documents issued by the CEPEJ. And one of them was about technological subsidiarity. It is an annex to the technological neutrality one. It means that basically generative AI is a solution, but not the only one. Firstly, you need to identify the problems and the needs. They're not the same. Once you've identified the problems and the needs, you need to analyze the millions of solutions that might be adopted to look at a need or resolve a problem. And artificial intelligence needs to be the decision that is adopted when the rest of the technological, non-technological solutions are inefficient or useless. So the state should not suffer the pressure of adopting artificial intelligence just because it is in vogue, but use it only when it is the most appropriate solution for resolving the problem or for looking at the solution. And this comes from different elements. Economist Carl Friedrich Frey distinguished between enabling tools and replacement tools. This is for creating a theory about the first industrial revolution and the fourth industrial revolution that we're in now. These enabling tools allow workers to foster his productivity, and the replacement tools make human beings redundant. The CEPEJ in the guidelines says that artificial intelligence needs to be an enabling, not a replacement tool. And this idea is present in the guidelines. So the subsidiarity, technological subsidiarity principle is, well, it should only be applied when it is the most efficient tool. Second aspect, what the use case, the appropriate use case are according to the guidelines. There's not a limited number in the guidelines as to where to apply artificial intelligence. There are figures about the different fields in which the risk profile is smaller, and then we can use generative AI. A large part of what I'm going to explain now has already been said, because Spain has lots of projects in which these fields are present. For example, the procedural management, judicial administration, predictive management of workloads, identification of mass matters, all those matters of company law, dismissals, where there are several workers. When the complaints are individual, we have identical cases. So this identification is interesting for the use of generative AI. Procedural management and information handling. Minute generation, automated minute generation, index generation, big files, citizen assistance services, chat box, specialized chat box for citizens, chat box, making easier the translation of legal documents, translating them to simple language. This is interesting because at the end of the day, when we talk about the problems and the needs of the administration of justice, we can know that the administration of justice can resolve certain problems by increasing the staff. Can we increase the staff to have lots of persons translating decisions into simple language text? No. Can we just use automating systems? No, not for this, but for other things. Yes, so we can distinguish between deterministic and non-deterministic software. Well, when A happens, then there is B. We can use that in many circumstances. But non-deterministic software is software in which the problem is polynomic and non-polynomic, structured and non-structured problems. Justice problems tend to be non-structured, so then we can apply artificial intelligence if the technological, non-technological solutions are not efficient, and when we have more benefits than problems. I will focus on the different phases. The guidelines also do something that is very important. These are the fields in which artificial intelligence can be used, or it is recommended to use it, or there is lower risk profile. Where should we not use it? Well, we should not use generative AI for tasks that are like evidence evaluation, and use of the rules when there is no jurisprudence background, all those practices included in the regulation on AI. And in this field in which Gen AI should not be included or introduced, I'm going to talk about philosophy of law. Manuel Atienza, a philosopher of law, mentioned the reasoning, legal reasoning. Decisions need to be motivated, and Manuel Atienza established two types of reasoning, internal and external. The internal reasoning or legal reasoning is the one by which we create a syllogism. We have a conclusion, or factical clauses, and well, I mean, a person going through the cash point and not paying, whatever. But what makes us judges is the external legal reasoning. And this is a cognitive process by which we justify why the greater regulatory premise is greater, why the smaller or lower one is lower. Why do we have a lower factical premise? Why, in the proven facts of the decision, you say that this person bought a product but never paid for it? Well, we have like a guard that saw the person go in and go out without paying. But how do you know if the person was carrying a product? Well, because there is a security camera that sees how the person took a product and put it in his pocket or her pocket. So we have evaluation of the evidence. The evaluation of the witness and video surveillance elements are assessed by the rules of the SANA critic. Secondly, why is it that the higher regulatory premise is such? Why are you applying this part of the legal or the criminal code? Well, because the person just stole a bar of chocolate, not a bottle of champagne. Well, it's about knowing why the proven facts are what they are, why we are applying this evidence, why we are applying the rule of Article 60 of the Social Security law for certain cases in favor of women, not of men. Well, because of the precepts on gender equality. So all these elements are the ones that are considered as not just being a syllogism. So this is what differentiates it from reasoning, legal reasoning.
¿De acuerdo?
This is a theory work. We analyzed for different debates the different steps and phases, but this is very important and is related to guidelines without prejudice. And I have to repeat myself that guidelines are a group document. We discussed every word, every sentence. Nothing is there without a purpose. And in the end, we are talking about guidelines, not impositions. They are just guidelines. And we changed some words because each of the words of the guidelines matter. We are going to talk about the different implementation phases. We have the preparatory phase. We have to have an institutional audit to see what are the problems, what are the needs, how we can solve them, what are the possible solutions that I can provide. We have to train the staff and come to protocols. And these protocols are not just to talk about cybersecurity. Protocols like what we call callbacks or flashbacks protocols. When you program things and you have a problem, a bug, you have like a callback, which is the possibility to go backwards and make it work again, just by correcting the mistakes. We mentioned the subsidiarity principle, which is essential in this callback process. You can go back without breaking the whole system. You can repair your mistakes to be more efficient. You have the possibility to introduce a system, but if you don't have the results that you expect, you can go back. So these callback processes are very important in the phases. That's why we have implemented audits to see whether these systems are working or not, if we have to correct mistakes or see different solutions or go back. So phase 1 and phase 2 now are about the document management, citizen assistance, etc. But phase 3 is the most important one, and it's about how to introduce in the daily work of judges AI or generative AI. Within phase 3, we have 3 sub-phases. One phase is about the suggestion of case law research. Another phase is about studying case law for concrete cases, summaries, etc. And then the next step would be to submit drafts on cases where we have a clear case law for specific cases. In Spain, we have payment orders case law, very well developed about contracts, etc. And the Supreme Court has made many decisions on that. But we also have what we call a cross-sectional element that protects the independence of justice. The first one is that every output of AI is not binding. And this is really important because judges do not have the duty to justify why he or she is out of the output of artificial intelligence. Imagine an AI system trained with text before the law of 1/2007, which is about the equality of women and men, and it is about the perspective of gender. AI trained, having this case law into account, could offer perfect drafts, but would not include that we have to adapt to the time in which we live, and maybe we have to get out of case law of the suggested draft by artificial intelligence, because otherwise we'll be frozen in our work. And the classic problem, we will have the problem of this frozen process. If it's binding and we have to justify why we don't agree with it, maybe we are putting our decisions into the hands of artificial intelligence. So we have to acknowledge the right of justice not to have artificial intelligence outputs if they don't want to. When you go to the judicial school as a judge, many of our colleagues try to solve the legal problems that were proposed. And we always said, okay, I have this case, what do you think? And I always said, tell me the case, but do not tell me what you want to do. Because if you tell me what you want to do, I'm going to interpret the case maybe in favor of your thesis or against it, according to my opinion on you. So judges need to have the right to get out or a little bit aside from others people's opinions and artificial intelligence drafts and opinions. Now I want to talk about tailoring solutions because in the past we always talked about commercial solutions like video conferences again, etc. And then we developed different tools through the implementation of specifications. Guidelines show that it could be very important to design tailored tools, but also contracts guaranteeing different elements like non-transference of data to different servers, agreeing with data protection regulations, etc. So the problem of using generative general artificial intelligence is that we transfer data to foreign servers. In the second place, since this is not as specific many times, we are going to have hallucination problems when we deal with artificial intelligence that generate patterns. If we use AI that are not tailored and we don't have the control of its infrastructure or model, it is very difficult to have an audit process. It is essential to have audits because the application of Gen AI requires transparency, supervision, and human work. With regards to humans monitoring or supervision, and I mentioned phase 3, we say that if we have minors or vulnerable groups of people, we cannot apply artificial intelligence systems. Anyway, the idea is to use solutions that are our own solutions, where we have the control of data, where we have the control of the training of the machine and the alignment of the process. The alignment of a model is very important. When you create a model, you have to align it, because if you because you need safety and security. Anthropic, for example, they developed cloud, and they had to develop a study about how aligning and touching the different elements of a system, cloud 4.5, and they align it so that every question creates an analogy with the San Francisco Bridge. What is La Paz? La Paz is like, what is peace? It's like the bridge, which is something that you have to cross to. Everything was just related to this alignment with the bridge. So if we don't know what is the alignment of the model, because it's generic and it's in the hands of a company, we will be lost. We will have an artificial intelligence that says that someone has to be in prison, but we don't know what is the reason behind it. So solutions have to be non-commercial and have to be in our control. My talk is going to be concluded with just a couple of things. The aim is that you read the guidelines. Guidelines are very interesting because they are like an academic paper, and they have a lot of references to different articles because we justify all forecasts with different scientific studies. And I'd like to finish my presentation saying that you, human beings, were chosen to judge other human beings. So don't let the machines do work for you. Thank you very much. So now we've been listening about the use of AI in the justice systems of Europe, but having seen the different aspects of the guidelines, we want to take the opportunity to show you the general landscape of these tools that we use in the Justice Department. And as Javier mentioned before, we have to talk about how the guidelines are structured and how guidelines propose AI in different phases. And this is inspired in how we have done our things in Spain. Phase 1 is about document analysis, and then we will see some documents and some tools. And we also had a first bot of dispute resolution. In a second phase, we wanted to talk about accessibility and support of the processing of cases. This is about the creation of drafts, qualification of alcohol levels, for example. And in a third phase, where we are now, we are just exploring advanced capacities. We are training multi-agent architecture and deliberative RAGs. And this is also related to the CEPEJ guidelines. The subsidiarity principle is also very important, but for us, it's more a kind of proportionality principle, because there's not a single solution for our problems. AI is not like a hammer that we need to use every time. It's just another tool which is very powerful, but we will have to see if it's the best tool for our problems. Maybe the result or the output itself is very important, but maybe it is very expensive at a certain moment in time. So let's explore other possibilities. Can it be explainable? Is it tools of AI? We always have different objectives in mind. As the sub-director says, this is not just because we have to. We try to promote governance, interoperability, and efficiency in justice. We try to focus on the citizens and professional people so that they can interact with us. And why not? We want to be a referent in terms of innovation in the administration of Spain out and in Spain. This is our portfolio, but I'm not going to get into much detail. I think if you are at home, you can have a general vision and then research in Google information about our systems. But let's talk about artificial intelligence. One system that you can use is Avia, which is our document assistant with artificial intelligence. There you can find anonymization tools, summary tools, simple summary tools, specific anonymization tools. And this can be applied to documents and different entities or parts of documents, which is very important. Javier Arcilla has mentioned that it is very important to distinguish between commercial systems and systems which are developed in-house. All the systems mentioned by the Deputy Director have the infrastructure of the Ministry of the President's Justice and Relations with the Courts. There is no data for third parties. When we have this type of processes, the information is stored for 15 minutes and then it is removed from the systems. All servers that are going to process and use these tools are with the infrastructure of the ministry, which is very important. But we have different nominal entities that we have detected, and the different elements uploaded to the systems thanks to an intensive training of months and months with a team of 5 people. Gathering documents, we have used our own databases, and these people said, okay, this is a name, this is a ID number, this is a place, this is such and such. And we had a double check process creating labels. With these labels, we have generated a system that identifies, and this is generative AI, it's not 100% true, but creates labels, and we can play with them, and we can acknowledge things and introduce elements in the systems and use the information to work smoothly. These anonymization and summarizing tools, as the Minister said, are offered in what we call Carpeta Justicia in our website. When people ask about the transformation of justice, we always say that we have 2 artificial intelligence tools which are perfectly safe because we use our own infrastructures, and every citizen can use them in the country. And this is just very successful. It's when international visits come and they see that we have created this service, they are really positively surprised. This is AIDA in Carpeta Justicia. We have other tools like AI services related with documents, like the applications of document anonymization. And we're also exploring tools to translate our documents into the languages of the European Union, following the Helsinki model and our co-official language. And the LexNet artificial intelligence. If you're at home and you don't know what LexNet is the electronic communication system between the legal operators of the country. This is one of the main systems that we use in the ministry. Data-oriented justice is good, but it has a problem. To have justice-oriented, data-oriented justice, we needed professional people to gather data and include them by hand in the form. But now we promote the use of a natural processing tool that scans the document, acknowledges the parties, and catalogs the document. And then this documentation is included in the system. The user has to review it, and once reviewed, like the name of the parties, whatever, you can have it. Do you accept it? Yes. Sometimes, and we can show you a video that we see some missing data because this is artificial intelligence. It's not 100% safe. And if you're not sure, the user can modify the information. But it's not just a traditional system. It's not something that we do by hand anymore. We are applying this system not just in LexNet, but other main systems provided by the ministry, like Ateneaires, which is our visor of judicial files. We see the possibility to generate summaries and have searches. You know that in this application, or with this application, you can see the recordings with texts. And then we have CEPEJ 2, which is a summary in the cases where you can consult information quickly. In the second phase that we mentioned before, one of the initiatives that we like is the fact that the minister, as a minister says, to make people understand the information. And this has been a possibility because of our first classification of documents, the identification of entities, and then the use of AI to simplify texts.
The first step is simple language, clear reading, so translating a legal text into a text that my grandmother could understand. It doesn't sound obvious, but in this case, well, the translation is direct. Obviously, this translation sometimes involves a reduction of the information offered because this reduction might be of very technical parts, and for the citizen to understand the message, they don't need the technical parts. So it doesn't mean that we're not providing them with the full information. We're providing them with both. And the next step is the easy reading. When the text is in a simple language, then these paragraphs are cut out following the corresponding ISO rules so that the phrases are clear enough so that every person with a disability can clearly understand what the text says. Here you can see, for example, a decision on a disability, ruling that the person needs support or guardianship in specific cases, what cases these are. So it is asking us to give the name of the guardian, so generates an easily readable text with every element of the guardianship in order to, well, help autistic persons, for example, to understand the message better. This document will never replace the decision, but imagine that you were in a desperate situation. Sometimes courts receive these desperate situations, and the administration that is not only providing the person with a decision, but they're giving them a guide. So the administration is proactively trying to help them simplify the complicated situation that they're in. And to conclude my presentation, there is a project that is very beautiful, the DCREG project, the digitalization of the civil registry. Two parts. One first part is a project, a normal digitalization project. Very old books are taken and little by little they are digitized. So we're like catching up on years. My parents will soon have their birth certificate digitized shortly. And in a second part, some of these books, well, it is not easy to read them. So we take a character recognition element to extract the information and dump it into the system. And lastly, I need to mention textualization. In 2020, Spain had textualizations. In 2000, well, sometimes it was more complicated in 2020 because with the masks, where this textualization, which involves transcribing from audio to text with AI, sometimes failed with masks on, but it is there since 2020. And this is unique because we don't need anyone to write down the minutes. But in hearings, well, the recording of the hearing, as you all know, this represents the minutes of the hearing. This minutes is associated to the transcription done by AI. So the tool allows to identify when the person spoke. I can download any type of legal order that is needed or decision. I don't need to try to be finding the statement of the person because it gives it to me. So it's giving very good results. Finally, to conclude, these are the criteria for tailored tools, commercial solutions. We always follow decision criteria that are well established in our legislation in many cases. We're not here to spend public money in things that do not yield results, but this event is proving that in Spain we are yielding tangible results. We always opt for models that allow for the maximum traceability possible, preferably European models like Mistral. We always offer data on real benefits of what we are achieving. Many countries have fantastic plans, and I would like many of them to show us practical cases on how they're using it. Legal security is always fundamental for us. Whenever we implement a project, we carry out a specific valuation of how, or assessment of how it could affect fundamental rights, for example. Security and sovereignty on data is very, very important. We always try to follow the proportionality or technical subsidiarity principle. And this explains, I think, that to us, technology is a means, not an end, but we always try for that end to be the best service, justice service for citizens as possible.
Bueno, y ahora como colofón del acto.
To conclude this conference, this event, in which we are giving you this very holistic view of how we are achieving the generative AI tools in Spain. Our objective was to condensate everything without leaving anything unexplained, but we have limited time and there are many things that we could talk about for hours. We would like to conclude this event that we've organized together with the European Commission for the Efficiency of Justice of the Council of Europe, not just talking about the digital transformation, but the role of Spain internationally. How we're not just a benchmark in digital transformation, but also in efficiency of justice. And for this purpose, we have invited experts who will be helping us work on that efficiency, and they contribute their time, they cooperate with the CEPEJ. I invite María José Chavarri, María Jesús Fraile, Cristina Lorenzo, and Marta García de Vicuña.
No, todavía Cristina. Bueno, muchas gracias. En primer lugar, me gustaría presentar a las expertas CEPEJ que me acompañan.
I'd like to introduce the CEPEJ experts. To my left, María José Chavarri, my colleague at the International Legal Cooperation Unit. She's a Spanish correspondent in CEPEJ, and she's also a replacement member of the working group for the modernization of the legal systems. María Jesús Fraile, government secretary of the National Court. Cristina Lorenzo, scientific expert in the working group for the quality of justice. And Marta García de Vicuña, who's just joined, and she's a replacement member on the efficiency working group for legal cases, legal procedures. This first round of questions, I'd like you to take it as an opportunity to explain the accumulated experience of Spain in CEPEJ so that we know what they do in CEPEJ and we are aware of how much we contribute to this international organization. María José, could you tell us about your role as a national correspondent in CEPEJ and your participation in the plenary sessions and the elaboration of indexes. Thanks very much, Alejandro, for giving the floor, first of all. Yes, I'd like to say that it is an honor for me to be here today participating in this roundtable with you as a moderator, having Maria Jesus, Cristina, and Marta in the panel, and with so many authorities of the public and private sectors, and of course the highest representatives of the CEPEJ. It is a pleasure for me to be here with all of you. I'd like to add to what you said that, well, I'm a justice administration official, and I also work in international cooperation, and I'm the correspondent of Spain to the CEPEJ. Recently joined the working group for the assessment of the CEPEJ judicial system, and parallel to this, since 2023, I've attended the plenary meetings of the CEPEJ. And this has given me knowledge about the work of this institution, not only from an operational point of view, but also from a strategic point of view, which is what the CEPEJ does. Looking at my role as correspondent of Spain to the CEPEJ, in a first approximation, it might look like the work of a correspondent is that of a data compiler, official data, valid data, and then translate them into data that are validated, consistent, comparable. But in truth, the role of a correspondent is more than that, because it also requires continuous cooperation with the actors, with the national actors, the national operators also participating in this data provision process. We all participate. The correspondent participates, the national operators participate. Cristina knows it. She's in the General Directorate for Digital Transformation, and we have a continuous dialogue. And we, when it comes to analyzing, examining the data. So the work of the correspondent is about compiling data, collaborating with the stakeholders, and, well, looking at how the CEPEJ's methodology has to be understood. And when it comes to providing data, we need to explain well what the data mean. They're not just numbers. There is a reality, the reality of the legal system of a country, and this is what CEPEJ wants to disseminate. In addition to this internal dialogue at national level, then there is a continuous dialogue with the Secretariat of CEPEJ, with the purpose of validating the data and getting them through this quality control process. In Spain, we have the participation of the different departments of the ministry, and also there is an active participation of the General Counsel of the Judiciary and also of the Prosecutor's Office. So it is an integrated effort of everyone, because it is not just about assessing or measuring the ministry or the prosecutor's office. It is measuring the work in Spain. It is absolute cooperation, absolute commitment with the CEPEJ culture, we could call it. When you internally go to the council or the prosecutor's office, they should know about the relevance of the evaluation or assessment exercise, and they should understand the importance of the data. The data reveal a reality that we want to offer in the best possible way. When the data are facilitated to the CEPEJ, CEPEJ creates two important tools: the report on the evaluation of the national justice systems, and at the same time, in this framework of cooperation between the CEPEJ and the European Commission, the data also feed a very important tool, the Justice Scoreboard of the European Union. And these two very important studies are not just a picture, a photograph, a statistical photograph. There's something more. These studies serve the countries for creating public policies, for exchanging best practices between different countries, and also fundamentally they are the basis of the decision-making, evidence-based decision-making. And it is a link between the national systems and the European environment, the CEPEJ, or the European Commission. And very briefly, in this 2026 fiscal year, we have been faced with two challenges. The main one, well, being that the questionnaires that we use have changed greatly, not just the general questionnaire that gives you an overall view of the legal system, but there's also been the creation of a new questionnaire specific, aimed at the technologies, the ICP questionnaire. These questionnaires have been given an annual character, and the calendar is more demanding because the dates for fulfillment of the questionnaires have been advanced. This means, or moved forward, so this involves more planning demands and a permanent internal dialogue to transmit all these innovations, also with regard to the CEPEJ, in order to try to technically explain our situation. But in Spain, in addition to this, and I'd like to convey this, we also have a new challenge that involves the new system of judicial organization established by the corresponding organic law in 2025. As I explained in 2025 plenary session, Spain has moved from an one-person organizational system with one judge, one legal official, and one team into a more collective system, and this impacts the idea of interpreting the data. All these challenges are accompanied by something which is a strength in Spain, and this is a high degree of involvement that I made reference to. The General Counsel of the Judiciary, the Prosecutor's Office, our ministry, like the Digital Transformation General Director, they've all made a big effort and they're very committed. I'd like to publicly say thank you for our joint work, because without you, it would not be possible. So this collective commitment will be the basis for 2026 to be successful as we expect. I think this is the overview of the role of the correspondent. I think it's a very good overview. Very often the international organizations have different roles that are key to specific functions, like a reporting on the state of our justice systems. Very often the changes that may occur in the institutions make us lose some coordination. And with events like this, I think we have the opportunity to go back to this momentum, realizing that it is a joint effort to demonstrate that our country is in a position of justice efficiency, which is what CEPEJ wants or goes after. Cristina, you've also been in CEPEJ for many years. In fact, you are repeating your mandate. What has a quality group been working in? Before anything, like Maria said, I want to express my gratitude with CEPEJ having come to present or introduce this guide or these guidelines that give visibility to CEPEJ, and the fact that they're introducing them in Spain, well, means that we have some expertise on artificial intelligence, and with Francesco and Ivan's leadership and the secretariat that is represented here by Daniel, well, yes, it is a second mandate. This year, in 2024 and 2023, I started at the end of 2023. I started as a member of the Justice Quality Group. For those who are listening, there are 4 working groups in the CEPEJ, which is a commission that has been in existence for over 20 years in the headquarters of the Council of Europe, which is an international organization that is older than the European Union. Of the 4 working groups, I am part of the Justice Quality Working Group. There is Cyber Justice, the EVAL Working Group, and the recently created Justice Efficiency Working Group. This year, I started to collaborate in the biannual mandate as an expert, as a scientific expert. But there's one thing that I'm very grateful for, that I highly value of these working groups, and it is the fact that the parties that are part of it, all the experts that are permanently there, we are all on an equal footing, and everybody who has something to contribute can do it without any obstacles. Of the 4 working groups, well, basically, the work that we've been doing recently, I will tell you about the topics, but I want to point out that the work done in CEPEJ is not an abstract work or ethereal work. Anyone might think that justice quality is a very big word and might only look at it superficially, but the work done in CEPEJ is much more than that, because it is about creating tools and guidelines that are useful for the countries, directly applicable, and that can be applied for professionals and for citizens.
I think this is the value of CEPEJ and the working groups and the tools that we create. With regards to the topics that we have dealt with in the last few years, and we mentioned it before, the checklist to promote the access to justice, which is not ethereal or abstract. It has a direct impact on fundamental rights. These guidelines are divided around 4 pillars. One is access to general information, which is important for citizens and professionals. And we know it in Spain because of the Carpeta de Justicia. And then financial accessibility, which is also important because without it we don't have access to justice. Physical access to spaces. When we have electronic means or electronic accesses, we can be more successful. In Spain, we mentioned the offices of justice in the different municipalities for people who are not close to big cities, and they can have this access to justice guaranteed. In the last place, hearings have to be accessible for everyone. And I don't want to get into much detail, but I want to comment on this final point because I have been part of it together with the rest of my colleagues, and I think it is one of the most important questions. It's just a checklist. It's easy to use, it's very easy to implement, and deserves to be known and communicated to the public. There is also another guide that we mentioned before, which is about the participation of minors in mediation procedures, family issues, etc. And this special consideration that we need to have with children to promote quality, but also equality in the access of justice. I would also want to mention guidelines, as Francesco perfectly knows, guidelines about the quality of the jurisdictional debate in civil and administrative matters. In these guidelines, we debated a lot questions like if we have to limit access in the appeals, the number of pages of appeals, and if this is agrees with the case law of the Court of Human Rights in Europe and with the rest of legal systems. These are just very simple examples. I could give more, but these are, the most important ones. I encourage everyone to get to know our tools and to check our information on our website on the website of the Council of Europe. You can select the tools and you can find very interesting and useful questions and issues. And we are going to send the guide by email. And in YouTube comments, we will have a link to everything that we have mentioned so that everyone can have access to the information. We've seen the work of the different experts that are parts of these processes, but I'd like to open up a little bit another debate, because we have CEPEJ experts, but we can cooperate in different working groups. And then we have cooperate in a specific projects like Javier Ercilla or María Jesús Fraile. María Jesús, I'd like to know more information about your work to spread the information, to get access to more things. If judges or prosecutors want to have more information or want to work with you, how can you be a CEPEJ expert? Alejandro, I want to thank you for the invitation. I want to thank the Ministry for allowing me to participate in this panel. I want to thank the participants and representatives of the CEPEJ for being here, and the recommendation of Javier and the work that his team has developed. My contact with the CEPEJ comes from this institutional representation of the Ministry of Justice in Spain in the committee. And in this participation as a national member, as a national expert, we were able to participate actively in the CEPEJ lines of work. In this huge work, compiling data for questionnaires, etc. It is very complex, but it is very positive, because we were part of a collaboration process where we have seen the importance of data for justice. And the CEPEJ has issued a report, and I cooperated in it. And then we review the result every 2 years, and allows us to know different data from different perspectives in terms of litigations, the name of judges per case or per inhabitants, accessibility to justice. And this, of course, helps, as María José said before, helps develop the participation, recommendations and debates on data, and to know the importance of data in the country, to develop public policies. So I think this is, a very important work, and I was really pleased to have been part of this process. In the active participation that we had in the CEPEJ, or that I had in the CEPEJ at that moment, the CEPEJ expanded a little bit the horizon, and as Cristina said, the CEPEJ wants to have more tools to be more efficient and to show them and help the different countries that want to use them and participate through different projects and also train other experts, and that's why we train experts in the use of the CEPEJ tools. The idea is to get to know the tools and to implement them in the different countries that are interested in the tools. For me personally, I had the privilege to work with fantastic people. The CEPEJ developed different projects with this junior and senior approach. We learned from the experience of people who knew more things, so I was in a privileged position, but now the CEPEJ, just a few years ago, is trained the different experts in the different tools of the different working groups that Cristina has talked about. The idea is to help other countries that are interested in the application of the tools because they want to apply them for a specific case or in a more general way, but always using the CEPEJ tools within this cooperation framework that guarantee efficiency. We are a little bit privileged because this is not just for other states, it's also for Spain. We can apply them internally, which is something that we are proud of. And there was a time where I knew the COVID tool, by heart, the backlog. It reduced the backlog, and I apart from helping each other, we can also help other countries. Marta García Vicuña, she's a public prosecutor and is the new incorporation of the CEPEJ. Spain now is represented in the working group of the efficiency of justice, which is directly related with the reforms encouraged by the ministry. Marta, can you talk about your group and how can we contribute as Spain? I want to thank you for giving me the opportunity to be part of this working group of the CEPEJ. This working group is quite new. We have had the first meeting in the first days of April, but it's going to substitute another working group which was about what we are doing now. This new group on efficiency is about creating tools that guarantee that the activity of justice is efficient for citizens. This is a very ambitious target. It can be very big, but it can tackle with different perspectives the organization of courts, training of staff, the development of tools to measure workload, reduce backlog, etc. In these two first steps of this new working group, we have analyzed two documents of two drafts about workload measurement systems in courts, and another one about guidelines to reduce the duration of civil procedures. We have analyzed the experience of the 8 pilot courts through different data and surveys, which have allowed us to see what are the main problems and the possible measures to reduce backlogs. I think that Spain can be or can play a very important role in this working group because we have a lot of experience with the new organizational model of the new organic law, and this can enrich the perspective of this group and the perspective of the rest of the working groups of the CEPEJ. This is a new organizational model that allows for a better specialization of judges and also the civil servants of the administration of justice. This creates scale economies when they develop their work, reducing backlogs. It also distributes better the workload among the different members of the staff and more flexibility. One example of the improvement of flexibility is that with this new model, the creation of position and the creation of a complete judge goes independently. In the past, we had a judge, a clerk, and different civil servants. So in the case of having the need to reinforce structurally staff of a specific judicial court, the only alternative was the creation of a whole new court. This new flexible model allows for a customized solution to analyze the bottlenecks, the needs of each body and institution to have the resources that are really necessary. If there is, if we need a clerk, let's, create a job or a position for a clerk, and this limits public expenditure. This idea, as the ministry said before, is about the creation of a lot of judicial positions, more than ever. The creation of this 500 position has a cost of 55 million euros against more than 2,000 that would be the creation of traditional courts. So I think that the improvement in the management of public expenditure is evident. We also have to take into account 42 positions of judges specialized in gender violence that were created in 2025, and the creation of 200 positions for prosecutors, which is 7% of the public prosecutor's office staff, which is a reinforcement of the judicial service as a whole. This organic law, efficiency law, has introduced another procedural reforms. The most important one is the introduction of masks, the means of alternative dispute resolution, with some exemptions related to the processes themselves, but generally the idea is to have an agreement culture limiting the number of litigations which are part of our system. This was implemented 1 year ago, and we have to be cautious to see how this is going to be implemented in the future, but the first results are being very positive. As the minister said, the reduction of litigations in administrative and mercantile courts in La Rioja, for example, was more than 20%, which is quite significant. For the first time in 10 years, we have reduced backlog of courts by 4.5%, and globally I think it's 0.65. And this didn't happen in the past, with the exception of the COVID. In 2024, it increased by 15%, and this backlog, this pendency. And this is related to the organization of courts, the introduction of this requirement, and the digital transformation that has made the implementation of this model possible, as we have mentioned throughout the day. So this is reducing litigations and providing a better service to the judicial system as a whole. Our experience in Spain can be useful for the CEPEJ work, and it will be a pleasure to continue working with the rest of the colleagues of this working group. Thank you, Marta. I think that it's going to be a pleasure to have you in the CEPEJ. I wanted to talk about what we are doing in Spain and about what we can do in the future. So what are you working on in each of the working groups? For example, Maria Jose. I've been named a member of the working group, and I have the knowledge of what my working group is doing. To give you some context, the evaluation group tries to have a methodology background. So the focus is in adapting this framework to capture in real time what is the real life or the reality of the judicial systems that are changing. specifically in the context of this digital transformation. The challenge that we have ahead of us for this working group is to measure something which is very difficult to measure, which is digital transformation. Digital transformation is changing all the time. It's, as Aitor knows, depends on many factors, and it's quite heterogeneous, not because of its implementation, but because of the effective use we can do from these digital technologies. The evaluation working group is aware of all the problems that we have, and that's why we are making a huge effort. The effort is about having a new questionnaire about the study of the different ICT technologies, which is specific, because in the past we had questions about digital tools in a general questionnaire, but now it's more specific, and it has a timeline. Every year we are going to publish a questionnaire with this data. So from the perspective of Spain, it's something which is very positive.
And also the working group has developed a tool that is an index, the ICT index, which does not only want to quantify how many tools every country has, it wants to go beyond capturing the reality of the countries and the nations. So that the true degree of deployment of the tools and also the use, how the use of these tools is incorporated into this legal system in everyday life, and the real impact. So the index aims at being robust, closer, allowing to extract and reflect the changing reality of the national systems, reflecting the diversity between the different countries in terms of the degree of digitalization and also the degree of development that every country achieves. In this, Spain has had a very active role since we knew in 2024 about the index. Spain has proven to be very interested, very curious about the index, how the various responses were assessed, how the figure was achieved, the final figure. It is very revealing as a figure, as a number, because it's not just a figure that puts you on a ranking. It reflects a reality, and this is why the evaluation working group has endeavored to create a figure that reflects a differentiated and diverse reality of all the legal systems. It allows us to have the most approximate photograph possible. In sum, the job of the evaluation working group is aligned with the mission or the purpose of the CEPEJ, which is to measure with rigor data that are complex, that are changing, measuring that in a way that allows for comparability between the different states, and it should be a useful assessment tool for creating the policies, the legal systems policies, especially in a digital context, which is what I was referring to. I think Spain's commitment to CEPEJ in this respect is absolute. And I think we are very positive about this new format of the questionnaire, of the questions of the index, especially the fact that we can revise or review it every year, because digital transformation changes quickly. Every country has different realities in their legal systems in terms of the technological implementation and the tools they use. And I think CEPEJ has taken a very good decisions when creating this annual technological index. Cristina, what do we see for the future in this quality working group? Well, of course, as Maria Jose said, one of the big challenges is digital transformation. Digital transformation really permeates all the fields in which justice works, because today we cannot understand justice without without a digital component in every area. I don't want to forget, before briefly saying what we are working on, I don't want to forget about what we can contribute to CEPEJ from Spain in terms of, in connection to what Marexu said, what the CEPEJ has contributed to Spain. In addition to all the issues, I have a very personal experience. When I started working in the ministry, I was advisor for the drafting of the new digital efficiency law, so the regulatory framework for the use of technologies of ICTs. This law, we worked on it under the leadership of the General Director for Digital Transformation, Aitor Cubo, but our working group was working closely with some experts from CEPEJ. Therefore, this influence of CEPEJ, I always like to remember that it is incorporated into our law on the use of ICT. As for the aspects that we from our Justice Quality Working Group, the issues that we will be handling, well, it has already been said that a biannual plan was created, the Valencia Action Plan, in which there were aspects related to quality of justice, like removing barriers for access to justice, making justice more human, with systematic and structured communication in justice, in addition to facilitating the appropriate means for dispute resolution. How it translates to the working group I'm working with, well, let me mention just some of the aspects. To me, the most important one, I think the one that will be having a very positive impact is the creation of a charter for the promotion of the trust of users and justice that focuses on citizens. The fact of putting in writing something so important as a promotion of the trust of citizens in justice is very much in vogue these days, because we all know about the geopolitical situation that we are in. And I think that promoting justice as something that can be reliable, something that citizens can resort to, is something that I consider as being very, very relevant. We will also be working on a document on environmental sustainability practices that I think Spain can contribute its experience to, and other aspects that will also be present, like the feasibility of developing indicators for measuring the quality of justice in cooperation with the EVAL group, because the working groups are not stagnated groups. They cooperate, or siloed groups. They cooperate with each other. Cyber justice impacts on all, but there are collaborations between the different working groups because the objective is one, only objective. One other tool that we are working on is about the interpretation in legal cases, like, well, aspects that any citizen can think about. The use of technological tools for interpretation, is it valid? In what cases? On what conditions? So everyday aspects. And of course, tools to continue promoting the use of mediation in the member states. As Marta pointed out, we have a very, very tangible example, which is the decrease in the number of cases in the administration of justice from a mandatory nature of the use of conciliation, mediation in company law cases, and the development for the compiling of mediation-related data in cooperation with the EVAL group. So as Marta said, the rest of the colleagues, what can Spain contribute? Well, we are performing the greatest transformation of justice in decades, and some of these reforms have been hand in hand with the CEPEJ at procedural, organizational, digital level. These are the reforms that have been tackled. They have been initiated, but of course we are prepared to facilitate our collaboration to the rest of the countries. Just because we did a few things, we were the first ones in doing specific things, nothing else. Being the first ones is sometimes a disadvantage, but it is an advantage for the other countries because they can learn from our mistakes, from what worked, from what did not work. We are faced with common problems in Europe, and this is why it's so important to have organizations and tools like CEPEJ for finding these common points where we can share, and of course we can come to individual solutions for common problems. Not for the states, but also for the citizens who are the ultimate customer. And talking about being the first ones, in order to conclude, before saying goodbye, I do not want to miss the opportunity. Maria Jesus, could you tell us about the digitalization of the national court, the Audiencia Nacional? Because the criminal scope of our national court is fully digitized. This is impressive because I know no other country has that. So, Maria Jesus, thanks very much for giving us the opportunity to explain this. Very briefly, I can only ratify what Cristina said, beyond what CEPEJ contributes to each country through all the tools. I think we can contribute to the CEPEJ with all the development policies that the Ministry of Justice is undertaking with this organizational efficiency, with this digital transformation. Specifically with regard to the Audiencia Nacional, the National Court, which is the body that I manage. Well, the Audiencia Nacional, the National Court, is a single legal body with exclusive jurisdiction in the criminal scope for judging organized crime cases, fraud, big fraud cases with international cooperation instruments exclusively for terrorism, financial crime. And then it is a legal body that has exclusive jurisdiction for mutual recognition aspects. So a difficult task for handling the digital transformation process, and the result is of great interest. A legal body that could be like in the second line, well, faced this transformation thanks to a strategic policy of the Ministry of Justice, and we came to where we are now. We are a fully digitized or digital body working on the zero paper concept. For 5 years in all the courts belonging to the National Court, for 5 years with this implementation of the electronic legal file, guaranteeing integrity, accessibility, security, with the push of telematic communications, having telematic means as much as possible, or establishing, when not possible, a mechanism for the paper version, means for paper version to not reach the table. Some persons have been more reluctant, some have been less reluctant, but it is now a consolidated process that can be an example to others and show that it is possible, it is safer, and in truth, it is possible to no longer talk about this internally because it is consolidated as a tool. It is true, we see this in the work that CEPEJ performs, the different projects where the expertise can be contributed. We see that digitalization is a key element, not only with this electronic legal file and the zero paper concept for with all the associated cost reductions, reduction of physical appearances. We're also referring to the use of video conferences, the use of recordings of hearings, the use of robotics, automation, being curious about and playing with artificial intelligence in such a sensitive legal body that is always present in the media because of all the matters that it handles. So this is experience that we know can be of use to others. It may be useful to CEPEJ. It can be useful to help finalize this process. So we are at your order. We are at your disposal. So thanks very much. So dear attendees in this Percent Palace and online, this event is now concluding. Thanks very much for your attention. But I'd like to ask you to reflect on what we are achieving for justice in our country. Our country is an international benchmark in efficiency and in digital transformation of justice. And this is thanks to the work of the people like my companions in this panel and all the people working in every court, in every prosecutor's office, branch, handling everyday cases, taking care that justice works. There are things that can be improved. Modernizing, transforming is an ongoing process. But along this journey, as in any other organization, the administration will find obstacles. When one of those moments comes, we hope that events like this can be of use for all of us to see things in perspective. And even with these obstacles, we can then be aware of what we can achieve together. Thanks very much.